So the original plan was for Catherine Lamon, who's the executive director of the Edley Center on Law and Democracy, to open the proceedings by doing a short introduction, and we were going to go from there. However, the microphone on the podium doesn't seem to be working, so she delegated to me as one of the faculty directors for the Edley Center. I think the Edley Center's name on Law and Democracy is pretty self-explanatory. We're really delighted today to have Dean Chemerinsky as our speaker, someone who I really can confidently say needs no introduction to this audience. Catherine was going to say all kinds of extravagant things about me, and I'm a little shy about saying them myself, but just imagine what she might have said. Our topic today is academic freedom and free speech in today's university. This is something that Dean Chemerinsky knows about both as a First Amendment expert and as somebody who lives on the front lines trying to decide where the boundaries of academic freedom are in his capacity as a dean. So one thing I wanted to mention, we're going to try to quit a couple minutes early to leave time for book signings and stuff in the hall. We'll see how that goes. And I'm really leaving it up to the dean to call a halt when he wants to make that transition. But with no further ado, let me turn it over to him.
Thank you. I want to thank Catherine Lehman and the Edley Center for inviting me, Dan Farber for moderating, and thank all of you for coming. What I was asked to talk about was a brand new book. It was published 2 weeks ago, titled Campus Speech and Academic Freedom, that I wrote with Howard Gilman, who's the chancellor at UC Irvine. As for any book, there is an origin story, so let me tell you about it because it explains what the book is trying to do. In 2015 and in 2016, when I was the dean at UC Irvine, Howard and I co-taught an undergraduate class titled Free Speech on Campus. And it was a seminar, and we were always surprised that the commitment to free speech from our students was much different than we expected and different from our peers. We began the first class by giving the students an example, and it was from a real-world situation. We're at the University of Oklahoma. A group of people in a fraternity were on a bus, and one of the members of the fraternity led the others in a very racist chant. The students who did this got expelled. And the question we asked our student is, should they have been expelled for doing this? And I was surprised. In 1 year, we had 15 students, and 14 said, expel the students. Only 1 said, don't expel the student. And as we went through the seminar, we realized that our experience with regard to free speech was quite different from college students' experience with regard to free speech. I can equate free speech with the anti-Vietnam War protests that I participated in. I remember the civil rights demonstrations of the 1960s. But they were as long ago for my students as World War I was long ago for Howard and me. And then I think our students equated free speech much more with the vitriol of the internet and of social media than with the more noble things of using speech to change government policy. And so we decided to write a book titled Free Speech on Campus, and it was meant to lay out basic principles of freedom of expression. And I have to admit, we were especially writing it for college and university administrators. The last chapter of the book is filled with suggestions of do's and don'ts with regard to the basic principles. We finished the book in 2016. It was published in 2017. Within 5 years, we realized that to a large extent, though the basic principles are the same, it was out of date. So much had happened with regard to free speech in just the short intervening years. I can give examples. In January of 2017 on this campus, Milo Yiannopoulos was scheduled to speak. Those are from the area to remember this. But Antifa had organized a protest, so much so that the then chancellor felt it wasn't safe for the campus to allow the speech, and it was shut down. It was criticized, including by the President of the United States, that Berkeley didn't allow the speech to happen. In fall of 2017, a campus group here that called themselves the Patriots said they were going to have a free speech week. And in that week, they were going to have Milo Yiannopoulos and Ben Shapiro and Ann Coulter and Charles Murray. And the chancellor, Carol Christ, asked me, did they have to allow these speakers, even though it would cost a great deal of money to ensure security? And I said, the law is unclear about how much you have to spend in order to protect the ability of speech. But I think the question is, what do you want the message to be? Because if you say no, you'll surely get litigated. The campus decided to have Free Speech Week. It cost the campus over $4 million in security costs. And the question would be, what if it wasn't Free Speech Week? What if it was Free Speech Month or semester? And it wasn't $4 million, but $40 million. Where can campus say no? UCLA, in response to this, set a budget for each quarter of how much they'd spend for security, and then said, we're not going to allow demonstrations beyond that amount. Is that consistent with the First Amendment? There were notable incidents at other law schools where speakers got disrupted. There was an incident, it was now UC Law San Francisco, where a speaker was coming and was disrupted. There was an incident at Stanford Law School where a federal Court of Appeals judge got shouted down. Well, the response was, but isn't there a free speech right to be able to stop a speaker by using expression? And I think the most important development in those 5 years, and one of the most important developments with regard to free speech in recent memory, is the laws that were adopted in many states to prohibit teaching of critical race theory. It started with an executive order from the Trump administration nearing its conclusion, and it was then picked up by many states. And it took a variety of forms, so often anti-CRT legislation or Stop Woke Acts or the like. And so we went to the editor at Yale Press and said, we think it's time for a second edition of Free Speech on Campus. The editor said, I don't think so. He said, what you need to do is write a new book that talks about all of the important issues that you didn't cover in the first book. And we signed a contract to do this in 2022 with the naive expectation we could produce the manuscript in 2023, and we didn't. We're both busy doing other things. And then the events of 2023, 2024 happened. We had events of October 7th and all of the things that occurred in campus after that. There were incidents in December of that year where 3 college presidents testified before a House committee, and 2 relatively quickly after that lost their jobs. There's a great deal of focus across the country on how to balance free speech with universities' obligations under Title VI and Title IX to not have hostile environments. There were encampments at over 100 universities across the United States in the spring of 2024. And in the midst of all of this, we wrote the book that I'm here to talk about today. We turned in the manuscript in the late summer of 2024. And the editor said to us, he's been doing this for decades, he was never so happy to see a manuscript not turned in on time. Because, of course, had we done so, we wouldn't have focused on what a lot of the book talks about, the events of 23, 24, though it's in a broader context. The other thing I have to say is that when we wrote the book, we never imagined that so much of it would be in the first person, talking about issues that he had dealt with as chancellor and that I've had to deal with here as dean. Let me just summarize the book for you quickly. I want to leave plenty of time for questions. The book begins by recapping the central points from free speech on campus. And our goal there was very much to summarize basic principles with regard to freedom of expression when it comes to college universities. And I would summarize them quickly in 3 points. First, all ideas and views can be expressed on a college campus. Period. The core of the First Amendment is that the government can't restrict speech on the basis of viewpoint. Now, of course, the First Amendment applies only to public colleges and universities, but there are other sources of law that often apply these principles to private schools. In California, we have what's called the Leonard Law. and it says that private schools, this applies to high schools as well as universities, cannot punish speech that a public school could not punish because of the First Amendment. Also, most private universities have faculty and student handbooks that promise protection of free speech, and courts have said that these handbooks constitute contracts, respectively, with faculty and students. The second principle that we articulate is that obviously freedom of speech is not absolute. We're all familiar with the famous quote from the late Justice Oliver Wendell Holmes that there's no right to falsely shout fire in a crowded theater. And the Supreme Court has identified a number of categorical exceptions where the First Amendment doesn't provide protection. An obvious one is child pornography is not protected by the First Amendment. For college and universities, the most important, I think, are first, that incitement of illegal activity is not protected. But it's important to recognize that incitement, as it's used in a colloquial sense, is quite different from the legal test for incitement. The legal test for incitement comes from a 1969 Supreme Court case, Brandenburg versus Ohio. There, the court said that speech could be punished only if there's a likelihood of imminent illegal activity and only if the speech is directed at causing imminent illegal activity. Imagine an angry crowd on campus. And imagine a speaker exhorts the crowd to commit acts of vandalism or even arson. If there was a likelihood that it would occur, imminently so, and it would be said that the speaker was directing that to occur, then that's not speech protected by the First Amendment. Of course, there's always going to be line drawing of when does speech rise to the level of incitement. Second category of unprotected speech are true threats. Just in 2023, in Counterman versus Colorado, the Supreme Court reaffirmed what it held in the 1960s. True threats are not protected by the First Amendment. And the court has made clear that there's not a First Amendment right to make somebody feel in imminent danger as to their physical safety. And the Supreme Court, in an opinion by Justice Kagan, said if somebody is acting with reckless disregard that their speech will cause someone to fear imminent harm to physical safety, it's not protected by the First Amendment. Imagine a student is walking across campus, and an angry group surrounds that student and yells at the student in a way that the student reasonably fears that he or she may be beaten. Even if no blow is struck, that's a situation where the speakers can be punished. And a final category of speech that I think is unprotected relevant to campuses would be harassing speech. Take the most obvious example. An employer saying to an employee, "Sleep with me or you're fired." The employer would not have a defense of saying, "But it was just speech." Likewise, in the employment context, courts have long said that speech that creates a hostile environment is unprotected by the First Amendment. The standard in employment, and it can be applied in education, is that speech becomes unprotected if it's directed at somebody or so pervasive as to materially interfere with employment opportunities based on race, sex, religion, sexual orientation. But you'll notice what I don't include in the categories of unprotected speech, and that's hate speech. We devote a whole chapter in Free Speech on Campus to it. In the early 1990s, over 360 college universities adopted hate speech codes. Every one to be challenged in court, without exception, was declared unconstitutional. The Supreme Court, in a number of cases, made clear that hateful speech is generally protected by the First Amendment. There was a case in 1992, RAV versus City of St. Paul. St. Paul adopted an ordinance prohibiting burning a cross or painting a swastika, vile symbols of hate, in a manner likely to anger, alarm, or cause resentment. The Supreme Court, 9-0, declared that unconstitutional. This is a way in which law in the United States is quite different than, say, in European countries, where it's very common for there to be hate speech laws. Some of the difference, I think, is that in the United States, any law that regulates speech cannot be unduly vague or overbroad. It has to be very specific about what expression is prohibited and what's permitted. it can't regulate more speech than the Constitution allows to be regulated. It is very difficult to draw a hate speech code that would meet these requirements as to vagueness and overbreadth. When Howard and I taught the undergraduate seminar, we would ask the students in exercise to try to draft a hate speech code. And they saw how enormously difficult it would be. But most of all, I think the reason that hate speech is protected in the United States is it expresses a view. It's an abhorrent view. It's a view that very much perpetuates the exclusion of those who've been traditionally discriminated against, and yet it is a view. And as I said under the First Amendment, college campuses, all ideas and views can be expressed. And the third general principle that we put forward is that colleges and universities can have time, place, and manner restrictions with regard to speech. Even when there is a First Amendment right to use government property for speech, it doesn't mean that all property can be used at all times. The Supreme Court has said that so long as the time, place, and manner restriction is content neutral, applies to all speech regardless of content, it will be allowed so long as it serves an important purpose and leaves open adequate alternative places for communication. In 2017, our then provost, Paul Avocedo, said, "Why can't we just have all the protests on the Lawrence campus several miles from here?" I said, "No, that's not going to be found to leave adequate alternative places for communication." But there are rules that are permissible. A campus can have a rule that says no demonstrations near classroom buildings while classes are in session. Campus can have rules that prohibit demonstrations at dormitories, especially at nighttime. This campus and many have rules prohibiting sound amplification equipment, especially during designated hours. There are a lot of hard questions that aren't resolved. One I already alluded to. How much does a campus have to spend in order to make sure that speech occurs? Where's the point at which it can say, this is just too expensive, and therefore we can't afford safety, so we won't allow the speech? But there is a good deal of law and context outside of college universities that clarify these rules as the time, place, and manner restrictions. We begin in the first chapter recounting all of what I've just said to you. The next chapter of the book focuses on campus speech and the concerns with regard to stopping discrimination, disruption, protecting safety. One of the issues that became very salient after we wrote Free Speech on Campus was the concern about how speech on campus can create a hostile environment on the basis of race, ethnicity, sex, and how to balance that with the obligations of the university under Title VI of the 1964 Civil Rights Act and under Title IX of the Civil Rights Law. Title VI says recipients of federal funds cannot discriminate on the basis of race. The Supreme Court has said this includes a prohibition against there being a hostile environment. Title IX says educational institutions that receive federal funds can't discriminate on the basis of sex. This includes prohibiting that which creates a hostile environment. And the Supreme Court has said in a series of cases that the burden on the recipient of federal funds is to not be, quote, deliberately indifferent. But what is it that schools are to do? Some have suggested that Title VI and Title IX create an obligation for the schools to prohibit the hateful speech that's creating a hostile environment. But the problem is Title VI and Title IX can't outweigh the First Amendment. They're statutes, and hate speech is generally protected. Catherine Lehman, who's our executive director of the Edley Center, before coming here was the Assistant Secretary of Education for Civil Rights and the head of the Office of Civil Rights. And she, in a number of speeches, said that colleges and universities have the obligation to respond to hateful speech that would create a hostile environment, even when it's speech that's protected by the First Amendment. And as we argue in the book, I think she's completely correct in this regard. But then the question is, what is it that colleges and universities need to do to show that they're not deliberately indifferent? Let me make this concrete by telling the story of a case that I argued in the United States Court of Appeals for the Fourth Circuit. It's Feminist Majority Foundation versus Hurley. It involves a public university in Virginia, Mary Washington University. There was a campus debate about whether to allow Greek life. 3 women wrote an op-ed in the college newspaper in which they opposed permitting fraternities on campus. They said when there's fraternities, there's much more violence against women. They were then targeted over the then social media platform Yik Yak with hundreds of messages. They were hateful messages. Some threatened them with rape and murder. They went to campus officials, and the campus officials said, "This is anonymous speech over social media. We don't have any obligation to do anything, and we can't do anything about it." In fact, university administrators put on their website, "We have no responsibility for anonymous speech over social media." The Feminist Majority Foundation filed a lawsuit on behalf of the women students. The university said, First Amendment, it's freedom of speech. The district court ruled in favor of the university, and I agreed to brief and argue the case in the Fourth Circuit, and I prevailed. And the Fourth Circuit said that even though it may be speech protected by the First Amendment, and some of it likely wasn't, still that doesn't mean that the college or university could do nothing under Title IX. For that matter, it said under equal protection. Now, there are many things that could be done. Campus administrators themselves could speak out against what was happening. They could provide physical protection for the students. They could engage in educational programs. And in fact, I think it was in the spring of 2024, Kathleen Lehman issued a Dear Colleague letter where she said much what I'm saying in terms of even if it's speech protected with the First Amendment, the campus can't do nothing, and listed a whole range of alternatives. Now, there's still lack of clarity in the law of what's enough to avoid deliberate indifference, but I think this is important in this regard. Another thing we talk about in Chapter 1 is disruptions. And simply put, there is no First Amendment right to use speech to disrupt an event or to shout down others. No court has ever found such a right. Otherwise, the only speech we'd ever hear is that which no one cares enough to shout down. And so I think that it's completely appropriate for schools to have rules that prohibit disruption and to enforce those rules. Our law school has such a policy. It's stated on the website. It's reiterated every fall, and take very much the position that there isn't a right to disrupt. Let me talk about the next chapter. I'll just quickly go through them so there's time for questions. The next chapter focused on campus speech in a different sense. Speech in a professional setting. Speech by faculty. Speech by students. And we're talking about in the classroom, in scholarship, in papers that students write, and the like. And here we focus on the concept of academic freedom. And one of the glaring omissions in the book that we wrote in 2017, Free Speech on Campus, is we really didn't spend very much time talking about academic freedom and its relationship to freedom of speech. I think of academic freedom and freedom of speech as, if I can use a Venn diagram, overlapping circles. There are some things that are protected by academic freedom that wouldn't be protected by freedom of speech. The First Amendment doesn't apply in private universities, though the private universities may still have a commitment to academic freedom. The Supreme Court has been very restrictive under the First Amendment for the protection of the speech of government employees on the job and the scope of their duties. And I can certainly go through what the law is there. Academic freedom is broader than what the Supreme Court has found to be protected by the First Amendment. But there's also things that are protected by the First Amendment that aren't protected by academic freedom. Academic freedom protects the freedom, I'm going to focus on faculty, in their teaching, their scholarship, their dissemination of ideas to the public, so long as it's within professional standards. And it's very important that academic freedom is within the scope of professional standards. Well, let me talk about what would be protected by freedom of speech but not academic freedom. Imagine that a professor goes to a rally on a weekend, and the rally has nothing to do with the scope of what the professor's teaching or writing about. Imagine that it's a chemistry professor, and the professor is going to a white supremacist rally. Freedom of speech would prevent a public university from firing that professor for going to that rally. On the other hand, it has nothing to do with academic freedom. It's not about the professor's teaching or scholarship or disseminating the ideas of the scholarship. The American Association of University Professors in 1915 articulated the first standards of academic freedom. They got substantially strengthened after the McCarthy era in the 1950s. But like freedom of speech, it's not absolute. Imagine that we assign a professor to teach contracts. And the professor says, I don't want to do that, and I'm going to protest. By every day, I'm going to come in and do nothing but talk about the sports headlines. We could discipline that professor. It wouldn't be protected by academic freedom. Or imagine a professor who's teaching modern 20th century European history, who is a Holocaust denier. That's outside the standards of the profession. That wouldn't be protected by academic freedom. Or imagine that a faculty denies tenure to somebody, deeming the scholarship to be insufficient. Or a professor gives a low grade to a paper because the paper doesn't meet the standards that are expected. Academic freedom doesn't provide protection in those circumstances. Let me give you a controversial example from this campus from December, just in the context of academic freedom. There was an electrical engineering instructor, a lecturer in a computing class, who at the end of his class adjourns the class and then engages in a statement about his views with regard to Israel and Gaza. What he was doing there was not protected by academic freedom. Now, we could say perhaps it was protected by the First Amendment. We'd say the university shouldn't discipline it. But since he wasn't engaged in teaching his class, he was teaching computer science, and in fact, in that instance, the class had ended for that day, there's no claim that academic freedom provided protection. One of the things that I've been interested in on this campus since the incident got attention is that many people want to put it in the context of academic freedom, and it isn't about academic freedom. That doesn't again say whether you should be punished or not, but just that it's a misuse of the concept of academic freedom. The third chapter, the fourth chapter of the book, the next chapter, focuses on what we call extramural speech. What about the speech of faculty and students off the job? And if anything, this computer science instructor speech was extramural speech. And we take a very strong position that virtually all extramural speech should be deemed to be protected for a public university in the context of the First Amendment, for a private university because we believe the same principles should apply to it. So, as examples, there are many instances of faculty and students facing discipline for their speech, say in op-eds, or for students, there's a lot of cases about social media. And we believe that so long as it's speech protected by the First Amendment, it should be protected from university discipline as well. And a lot of what the chapter goes through is the many instances where this hasn't been followed. The next to the last chapter of the book focuses on the laws that have been adopted restricting teaching of critical race theory, anti-woke, and the like. And we argue, and try to argue strongly, that these should be declared unconstitutional, that many different grounds. Most of these laws, if not all of them, are void on vagueness grounds. They're very vague in terms of what they're prohibiting. Also, there are content-based restrictions on speech. Also, we think there's real equal protection issues that are raised here. And if you haven't seen some of these laws, some go very far in terms of restricting what faculty can do. So, for example, Indiana has adopted a law that requires that every professor in every class have balanced treatment of the subject. And a professor could not only be disciplined, but have tenure revoked for not providing balanced treatment. If we're talking about the institution of slavery, we're talking about Plessy versus Ferguson and separate but equal, why would we want to have balanced treatment? Professors teaching about the Holocaust, there's no balanced treatment to have there, and yet the law has no such exceptions. So far, the challenges to these laws have been largely successful, not entirely so, but we make the argument is that we believe they should be found to be unconstitutional in chilling speech. Some of the difficulty is something I alluded to earlier. The Supreme Court has said that the First Amendment provides protection, no protection for the speech of government employees on the job and the scope of their duties. There was a case called Garcetti versus Sabalas in 2006. It involved a district attorney in Los Angeles County who believed that a witness in one of his cases, a deputy sheriff, was lying. He wrote a memo to the file to that effect. His supervisor, who had been my student at University of Southern California, told him, change the tone of the memo. He didn't, and he gave it to the defense lawyer as he thought he was constitutionally required to do. He then got moved to a less desirable position, removed from his supervisory authority, and he sued, saying, this is punishing me for my speech. And the Supreme Court 5-4 ruled against him and said there's no First Amendment protection for the speech of government employees on the job and the scope of their duties. The state of Florida and the state of Indiana are taking the position that all professors are government employees and all of their teaching and scholarship in the scope of their duties, and therefore there's no First Amendment protection. We argue strongly why this is wrong in terms of what universities are and should be about. Now, the United States Court of Appeals for the Ninth Circuit, in a case called Deemers versus Austin, last year the United States Court of Appeals for the Seventh Circuit have said there is some protection for professors when they're engaged in teaching and scholarship. But even then, it's not a great deal of protection. There's only First Amendment safeguards if the speech involves a matter of public concern, and only if it can be shown that the speech interests outweigh the university's interests. But still, there is some protection there. And we argue, in light of this, that the state laws restricting teaching of critical race theory should be declared unconstitutional. In the last chapter of the book, we do just what we did in Free Speech on Campus and try to be prescriptive. It's, as I say, written for college, university administrators, and it's a series of do's and don'ts. It always feels presumptuous for me to give advice like that, but this was our chance to try to provide guidance to college and university administrators. Now, I started what I think is with the premise for both of these books, and that's that campuses should be places where all ideas and views can be expressed. And this is controversial in some circles. And I guess my way of defending it is ultimately, I believe that my speech will be protected only if I safeguard the speech that I don't like today. That I think that the First Amendment, and for that matter, academic freedom, are based on the assumption that we are better off having all ideas and views expressed than giving the power to the government or those charged, whether it's the president, the governor, the chancellor, the dean, to decide what ideas we can and can't hear. That ultimately the First Amendment is based on that faith, that we're better off letting ideas be expressed than giving anyone the power to tell us what ideas we can and can't hear. And that's a faith I very much share. So I was asked to talk a half hour, and welcome your comments, questions, anybody else's.
Well, perfect. Thank you.
Thank you. Thank you.
So I was asked to comment. Well, I actually was part of formulating the ask. So Catherine and I asked me to speak for 15 minutes and give some comments on the book. And I think you can tell just from the presentation that it's a lucid analysis of the issues raised in a whole host of different situations, mostly under the First Amendment, but to some extent under concepts of academic freedom that are maybe distinct. I think anybody who is worried about these issues, let alone any administrator or university council, would be greatly benefited from the book. I think, given limited time, I want to start where the dean left off with the question of, yes, okay, you've told us what academic freedom means and how that applies, and what the First Amendment, how that's interpreted by the court and how that applies, and we're not buying it. Why should we accept that perspective? Particularly people who think that, in fact, universities are not forums where all ideas can be debated, people who think that certain ideas are being repressed in the university context, and that can be from the right or the left, In thinking about it, I actually was thinking more about it from the right because I think a lot of the initiatives we're seeing are coming from that direction. I was just looking last Wednesday at the headlines, and just on that one day, there was something about a Texas A&M lecturer who was fired over a lesson about gender. Professors being watched. Apparently, some universities are requiring that all classes be videoed and the tapes posted, not just for student use, along with syllabuses and other things. And then the third one was Trump escalates Harvard fight. So we can see that these are pretty live issues. So what if you think universities are pretty imperfect, that academic freedom in practice doesn't live up to the ideals that we have for it in principle? Why should you still be worried about academic freedom and the First Amendment? Well, I think one reason that we've really been getting a sort of master lesson from the Trump administration about is the reality of chilling effects. And I can recommend one of the dean's previous books on chilling, which goes into this. But I think what we've seen is that it's maybe a much bigger issue than we might have thought. I mean, what we've seen is all kinds of people, from professors to universities as a whole, law firms, et cetera, just sort of tucking their heads in and, going into the, I don't know, the, get under your desk and cover your head earthquake warning, just at the possible threat of some kind of sanction or even public censure, right? And I mean, the reality is most people and institutions want to get on with whatever it is that they're wanting to do. They don't want to get mired in controversies. And therefore, they will steer well clear, which means that even if you think some speech maybe should be suppressed, you really have to think about the possibility of what will happen to others and how those legitimate seeming anyway, restrictions on speech could be exploited to use as leverage against unpopular ideas or groups. Because even if there is a valid First Amendment defense, generally people don't want to go to court. It's expensive, it's time consuming, it results in all kinds of hateful postings on social media, and so, they'll cave. So I think that's one really important factor that we've been learning about. I think a second thing that we've been learning about is that although we can all agree that in principle, the world would be better off if certain ideas were not, if everybody just agreed those ideas are off the table and we're not going to talk about them ever, we can't agree on what those are. I mean, we can agree on some of them, but those are really easy cases. What we can't agree about in practice is, for example, what kinds of discussions of race, what viewpoints are impermissible, which ones are permissible, right? We've learned there's just a very deep division on that issue. And a third thing I think we've learned is that we really just can't trust the government to make these distinctions, right? It's all very well when you're thinking the government will be considered composed of like-minded, of reasonable people making reasonable judgments. In other words, people who are more or less like you. But there's no guarantee that that's going to be true in practice, right? So all of this, I think, adds up to a very strong argument for writing rules about academic freedom, about free speech that really lean over backwards, right? That I way back when, as part of a settlement of a free speech case against the University of Minnesota, they agreed to a training session on the First Amendment for senior university administrators. And I got to give the training session, to a group of people who were obviously sort of wish they weren't there. And one of the things I said is, look, just because something seems reasonable to you does not mean it's constitutional, right? What I've just been giving are the reasons why, in fact, there are things that might seem reasonable that we still should not allow for one reason or another. The final thing I would like to say that I think is maybe for those who haven't taken First Amendment courses and haven't read the book to know about the boundaries, I think in some ways you can see a parallel between the university and the courtroom, right? So within the courtroom, we have rules of decorum, we have professional standards, we have a process that is supposed to be adversarial but get at the truth, and it's designed more or less to try to go in that direction. You can't talk about things that are unrelated to the case in the courtroom. You have to abide by rules of evidence, all kinds of things. So that's the classroom, in effect, or the scholarly journal that's like the judicial opinion, right? So on the other hand, once you're outside of the courtroom itself, you're entirely free to say terrible things about the judge, the lawyers, the issues. You can parade outside and protest, right? And that's an entirely different set of issues. So I think some of the things we're talking about have to do with the, remembering that although in some ways classrooms, say, are open forums, they're open forums within limits that are dictated by their purpose, which is fostering knowledge and critical inquiry. And the restrictions are only justified if they relate to that. Okay, I want to leave plenty of time for Q&A, so
Questions, comments, anything? Please. Thanks, Jenny.
Hello. Thank you so much for this book and this talk. I have a question about requirements of professors, in syllabi. There's lots of language that are required for professors to include. I know there was a recent case about land acknowledgements, and a professor not wanting to do that in their syllabus. Can you comment on anything?
Let me tell you about the case. It's in the Ninth Circuit. It's in December, and it involves a professor at the University of Washington teaching a large required, I think it was 5% engineering class. And rather than put in the land acknowledgement that was recommended, not required, he wrote a parody land acknowledgement that was perceived to be disparaging to Native American students. He was not actually disciplined in any way, but he was warned. And you would say a warning is a discipline, but he didn't lose his job, pay wasn't cut, anything like that. And he sued. And the Ninth Circuit, in a 2-1 decision, ruled in his favor. Interestingly, in terms of the politics, the two judges in the majority, Dan Bress and Mylon Smith, would regard as conservative judges, and the judge who dissented, Sidney Thomas, would regard as the more liberal judge. And I think the interesting question is a professor's syllabus to be regarded as part of the teaching, the writing? It is judged by professional standards or judged by First Amendment standards. But the Ninth Circuit 2-1 ruled in his favor. My sense is the only things that here at Berkeley Law we require to be in the syllabus are those that are mandated by accreditation. Professors are required to put learning objectives in their syllabus, but I don't think, at least if it is required, I violated that requirement all the time. Because the only thing I have is, the introduction and then the assignment sheet. But I think that ultimately you'd come back to the basic principles of, is this academic freedom? Is this part of the teaching of the material? And in terms of First Amendment, in the Ninth Circuit, the only First Amendment protection for speech on the job is that related to teaching and scholarship. And so should we say that his parody land acknowledgement is teaching? If you're interested, I can share with you a column I wrote for the Daily Journal about this case. Chris? Sorry, Jenny.
The book is great. I've read it twice. Thank you so
Oh,
much.
you were so
It's
kind.
So clear.
I will pass it on to Howard.
Everybody should read it. I wanted to invite you to comment on the Regent's recent policies expressing some constraint on extramural speech, and the results being things like the DeCristo case. And so I think you said that virtually all extramural speech should be protected, but our regents are saying that if there's sufficient institutional disruption or frustration of the institution's mission, there could be punishment. Could you comment
Sure.
on what you think will happen with this?
And as I understand it, is a policy is pending before the Regents. Is that right? And I oppose that policy. And let me go back to some law that I described really quickly, and then I think I can explain why I oppose that Regents policy. The general rule is there is no First Amendment protection for speech of government employees on the job in the scope of their duties. But for speech that's off the job, extramural speech, or in the Ninth Circuit at least, under Demers versus Austin, speech that's related to teaching and scholarship is treated under a standard from Pickering versus Board of Education, a 1968 case. And I stated the test very quickly. In order to be protected in this realm, it has to be speech that's of public concern, and the speech is protected unless the government's interest in preventing disruption outweigh the speech interests of the government employee or the faculty member. That case involved a high school teacher who wrote a letter to the Joliet newspaper. And what the Regents, I think, whoever drafted this and were trying to do, was track the language of Pickering versus Board of Education, saying that the speech isn't protected if its disruptive effects outweigh its speech benefits. The problem is that's a very vague standard. It is written that way, it's going to chill a great deal of expression. And my hope is that the University of California would provide more protection for extramural speech for faculty and students than the First Amendment necessarily would provide protection for. That I don't think the University of California should say, if it's not First Amendment protected for a government employee, we reserve the right to punish it. And I think that's what the Regents would be doing with that policy. And as I said, especially because of the chilling effect of the speech, I would oppose that policy.
Thank you. This is very helpful. And one question I had about hostile work environment is that even that term seems a little bit ambiguous because it has a value judgment, and whether it has been defined as outright insults or more subjective standard where the person feels that the values that are being expressed are somewhat antagonistic to that person for whatever identity they have.
It is an objective standard, but in the context of the workplace, it has come to focus on the reasonable woman who would be subjected to this, or the reasonable person of color, which starts to blur the objective and subjective. But since it's still put in terms of reasonable, sitting next to a torts teacher, it still would be regarded as an objective standard. There is an ambiguity to it, just like there's an ambiguity in terms of what constitutes incitement or what constitutes a true threat. Though in the employment context, there is a huge body of case law defining when something becomes a hostile environment. And I stated the standard quickly, generally focused on speech that's directed at somebody. And so in the campus context, there was an incident of a noose being tacked onto the door in a dormitory of a room occupied by a black student. That would certainly be enough to constitute a hostile environment because it's directed. If it's not directed, then the question is it sufficiently pervasive to materially interfere with employment opportunities based on race, sex, religion, sexual orientation? And what's enough for pervasive? Is one instance of using a racial epithet enough? How many would be enough? And there's again, lots of cases and they don't always come out the same way. And I think that in the education context, You can borrow a lot from what's developed in the law with regard to employment, where there's so much more in the way of cases.
Can I add just one word? I think, I don't know if this helps clarify our thinking or not, but I think it's pretty clear that the Trump administration, at least implicitly, is applying the similar kinds of rules to speech that might be perceived as hostile to whites or men. That might give us an opportunity to at least think about how tightly we want to draw the lines if the same rules are going to, this is all part of the Supreme Court's push for colorblindness and the Trump's administration sort of enthusiastic amplification and expansion of what the Supreme Court has said.
And I think, when we're talking about the Trump administration, one of the things that it's done is claim that Title VI is its basis for cutting off funds to universities on account of the universities having been deliberately indifferent to speech that creates a hostile environment for Jewish students. One of the things that doesn't get enough coverage there is no one knows better than Catherine Lehman, Title VI has all sorts of requirements before money can be cut off. There has to be notice, and there has to be findings of fact. There has to be 30 days notice given to the House and the Senate before the cutoff of funds. The cutoff of funds can be only as to the part of the program that is deemed to have created the hostile environment. The Trump administration has followed none of those limits when it's invoked Title VI. And I think that's something that's important in the conversation. Any other questions? Please.
Hi, yes, thank you so much for your speeches. And I can absolutely understand the hesitancy to put any kinds of guardrails on speech, especially given the instability and polarization in the United States. But if you feel like you can talk to this, I'm curious, you mentioned hate speech is outlawed in Europe. And I'm curious, outside the political conflicts of getting there, what are the consequences of a policy like that on college campuses? And I'm particularly interested in this in the context of increasing polarization in Europe today.
I do not minimize the harms of hate speech. Hate speech very much perpetuates exclusion. People have traditionally been excluded from college universities. But what you're asking is about practical effects. One of the things that I learned as we were researching the book is how much hate speech laws have been used against the very groups they're meant to protect. The University of Michigan adopted one of the first hate speech codes, and it was in response to some really vile racist instances of speech on campus. Between the time the University of Michigan adopted its hate speech code and when the federal district court declared it unconstitutional in Dover, Michigan, every enforcement action under it was brought against black students and Latino students. And this has been a pattern elsewhere. In the context of European hate speech laws, when England adopted its hate speech law, the very first prosecution against it was against someone for advocating for Zionism, where they said we regard Zionism as a form of racism. We can agree or disagree with that. The most frequently prosecuted person for a long time in France was the actress who recently died, Brigitte Bardot, because she was an animal rights activist and was sharply critical of religions that engaged in harm to animals or sacrifice to animals. So when you actually look at how those laws are used, it to me makes me even more worried about allowing them. I'm not sure if that's answering the question, but can give you a lot of information on how they've actually been used. Nadine Strawson has written a book about hate speech laws where she goes through lots of those examples.
Yeah, I think it's a really interesting question in terms of what we might be able to, I can't answer it, but in terms of what we might be able to learn from what's going on in Europe now, which is that we've seen the rise of far-right, anti-immigrant, often racist political parties that are sort of beginning to surge in a way, that might seem familiar to some of us. Did anti-hate speech laws delay this, or has it moderated this, or has it had no effect? if I were a sociology professor, I'd be trying to figure out, I'd be writing a grant application, but I don't know the answer to that.
I want to thank Catherine Lehman again and Dan Farber, and thanks to all of you for coming, and really such a pleasure to get to talk about my book. Thank you.